The topic of my presentation is negotiation. Negotiation is a process that literally means objective based discussion, meaningful talk, and direct communication. It refers to exchange of expressions and comparing of apparently inconsistent views on some issues. Don Peters, who is a professor of law at University of Florida, says that negotiation encompasses any exchange of information made by two or more parties in search of an agreement to do or refrain from doing something. Negotiation occurs when suggestions, proposals, solutions, offers, counteroffers, concessions, positions, and arguments are shared. There are some essentials which must be included in negotiation. Direct communication mechanism. The objective of negotiation is the resolution of disputes and differences. Consent of the parties. Negotiation can only be stimulated by the consent of the parties. The outcome of negotiation is not binding on any of the parties. The procedure and formulation of solution remain in the control of parties in negotiation process. There are some phases of negotiation. First one is preparation. In the preparation phase, parties are to prepare and collect the material for the process. For the reason, they are to state their case, and the opposite party would not be made satisfied on the basis of mere stories. Opening. In the opening stage, both parties come to know about the initial position of the other party. Initial position would expose the maximum expectations of parties. Bargaining. The bargaining stage narrows down the differences. The parties need to develop a realistic approach in this phase. They should keep their expectations in the light of situation developed during the process. They must accept that a mutually acceptable agreement could never be reached unless there is something withdrawal from their initial positions. Each party ought to mentally ready that he would be supposed to give some concessions to the party in order to achieve something. The closing phase. The closing phase is the formulation of final agreement, a compromise deed that will tie the parties in contractual liabilities. This is the fruit of the whole process that reestablishes terms between the disputing parties, that brings them to a state of sympathy and cooperation. A successful negotiation process need the following essentials, which are cooperation, avoidance from irrelevant discussions, consciousness about time constraints, belief of the parties that no other mechanism can bring settlement of their disputes, belief of the parties that a mutual agreement is not something impossible, admittance that to leave some and to take something. It is the fundamental feature of the negotiation process. Cooperation means that the party should sacrifice his own interests in the voting circumstances. In simple words, we can say that a party must has to leave and to get something in order to bring the settlement of their disputes. There are some strategies of negotiation. The first strategy is competitive or adversarial strategy. In this strategy, the focus remains on the obtaining of objectives. The party wishes victory at any rate, even at the cost of the other. The party takes an extreme position and tries for one-sided gain, which is win-lose strategy. With this, there is a very limited scope of concessions in this strategy. The party wishes the outcome in the shape of win-lose approach and searches for an agreement that may benefit him only rather than approach that would benefit to both of the parties. To achieve the goal, the negotiator uses various tactics and generates maximum pressure on the other negotiator. This is a blind approach to joint gains. In situations like this, the chances of arrival to an agreement highly decreases because both the parties want win-lose situation rather than win-win situation. There always remains likelihood of breakdown and impasses. As a result, threat to the future relation of parties becomes probable. The second one is integrative or interest-based strategy. In this strategy, the focus remains on amicable solution. The peaceful settlement is the main objective. The strategy adopted is to make concessions, to ensure gains, and to maintain good relationships between the parties. It may sometimes demand the sacrifice of one's own interests. This kind of negotiation is also called the soft negotiation strategy. Negotiation as regard to its subject and approaches. Negotiation is divided into two groups that are dispute negotiation and transaction negotiation. Dispute negotiation, in this negotiation, the focus remains on resolving existing issues to bring the settlement of the dispute. In transaction negotiation, the main focus is on reaching agreement for the future. Some researchers have considered the various strategies of negotiation as its kinds. According to them, negotiation is of two kinds, the distributive and the integrative negotiation. There are some kinds of negotiation with respect to its features and outcomes. The first one is avoidance. In this kind, there is no win situation at all. The negotiator who prefers a peaceful resolution at any rate loses all or some of his claims. In order to just bring the resolution settlement of their dispute, the people who avoid taking of risks due to some other priorities usually adopt this approach. Competition. The negotiator in the competition phase who wants to achieve all of his claims through negotiation process is deadly rigid. He wishes to protect his interests even at the cost of the opponent. Negations in these situations may only be successful if the other party is avoider. If the other party is not avoider, then the negotiator then the negotiator cannot win the negotiation process, and the negotiation process will automatically fail. Such negotiator is called competitor. Accommodative. In accommodative, a negotiator sacrifices some of his interest for the party. It means that he gives some concessions to other parties in order to sort out the dispute between them. He does not perform like the avoiding disputant. He is also not like a rigid negotiator who just wants a win-lose situation rather than win-win situation. He is rather cooperative in nature. His grade lies between the avoider and the competitor. The last one is compromising. In this kind, the very nature of the negotiator inclines towards a compromise. He can be placed somewhere, for example, between the assertive and cooperative parties. He accepts all that is expedient, and that's why he does not reject partial solutions as it minimizes the bulk and strength of differences. We can say that in this kind, the negotiator just wants the settlement of their disputes. For this sense, he may leave some of his interest or all of his interest. Thank you.